It's important you know the correct legal procedures if you plan to file for divorce in Oregon. In this video, a licensed Oregon attorney will answer common questions and share how OregonDivorceForms.com can help you file for divorce using our various divorce form packages. What is the divorce process like in Oregon?
Oregon is a no-fault state, meaning you do not need to have a reason to file for divorce. In fault states, you must have a reason such as infidelity, cruelty, or abandonment. But in Oregon, if you no longer desire to be married anymore, that's reason enough, which is called irreconcilable differences. The divorce process can be divided into 4 stages: initiating the divorce with the petition, serving the divorce on the other spouse, litigating the divorce in court, and finalizing the divorce with a judgment. Most Oregonians go through these stages without the legal representation of an attorney, meaning they are self-represented. This seems to be due to the cost of hiring an attorney, having more control over the case, and the belief that involving lawyers will escalate things. However, when going the do-it-yourself route, many tend to struggle finding good instructions on how to correctly fill out their divorce forms, which leads to costly mistakes. Divorce is a tough, emotional decision. Once you're ready to make that decision, you'll need guidance and instruction to help you get through it, which is what OregonDivorceForms.com is all about.
How do I get my divorce started?
A divorce starts when one spouse files various documents with their county courthouse. Among those documents is the petition, which is an important document. The spouse starting the divorce is called the petitioner, and the other spouse is the respondent. If you're the one initiating the divorce, the petition is the document where you inform the court of background information regarding the family, like when you married, if you have any children, and what assets and debts the two of you own. It's also where you ask what relief you want the court to grant, such as how custody should be awarded, what parenting time should be, how property and debts should be divided, and various other requests. If you want to get your divorce started, our initiating forms package will do just that.
How do I get sole custody of my child?
In your petition, you must request to be awarded sole legal custody of your child. The custodial parent has the exclusive right to make major decisions concerning the child, including the child's residence, education, healthcare, and religious training. Joint custody is where both parents share in those responsibilities. After you file your petition, your case may conclude by either default, agreement, or trial. A default means your spouse did not participate in the divorce. If your case goes to trial and custody is an issue, meaning the parties disagree on who should be awarded custody, the judge will decide custody based on various legal factors. In our forms and video tutorials, custody, joint custody, and the custodial factors are explained further. In the initiating forms package, we provide entries where you can request sole legal custody.
What should I include in my parenting time plan?
A parenting time plan may be either general or detailed. A general parenting plan must set forth the minimum amount of parenting time and access a non-custodial parent is entitled to have with the child. In developing a parenting time plan, the court may only consider the best interests of the child and the safety of the parties under Oregon law. Our initiating forms and default and judgment forms contain several parenting time plans to meet your family's needs that have been previously accepted in Oregon courts. Our plans include a standard parenting plan, which works for most people, a safety-centered plan for when there are issues involving drugs, alcohol or domestic violence with one of the parents, and a medium and long distance plan for when the parents live over 60 or 180 miles apart, respectively. If one of these issues resembles your situation, we give you plenty of instructions on how to put together a parenting time plan.
Which spouse pays child support, and how much will that be?
In Oregon, typically the first step is to calculate the support amount using the Oregon Child Support Guidelines calculator, which will determine how much money each parent should contribute for the care of their child. Generally speaking, the spouse with less overnights will pay child support to the other spouse, but there are other factors involved, such as income, health insurance, childcare expenses, and non-joint children credits that may affect the calculation. After all the information is inputted, the calculator will give an amount the non-custodial or non-primary parent may be obligated to pay to the custodial or primary parent for the support of the children. Our initiating forms package goes through the calculation as well as the information that must be given to the court to determine child support. Our default and judgment forms show you how to correctly input the necessary information into the judgment so that it becomes part of an order that may be enforced by the Oregon Division of Child Support. This is important because the Division of Child Support enforces wage withholding based on the calculation.
How will property and debts be divided in a divorce?
Property and debts are divided by either default, agreement, or trial. If your petition is not contested or your spouse agrees with how you want property and debts to be divided in the petition, the distribution can be submitted to the judge for approval. If your spouse contests the proposed distribution, then the judge gets to decide. The judge will want to know whether property was acquired before or during the marriage and if the property was used separately or jointly. The judge will also consider whether it makes more sense for one spouse to keep the property, for example, the family house for the parent who will be the primary parent for the children, and any other factors the court deems to be just and equitable. Just and equitable is a legal term used in Oregon, which essentially means what's fair given the circumstances. OregonDivorceForms.com makes the sorting of property easy by containing a property and debts exhibit sheet in both the initiating forms and the default and judgment forms. This simplifies the sorting of real property, personal property, and debts with convenient categories such as vehicles, furniture, jewelry, and real estate, for example.
What happens after I file my initiating forms? Does the court notify my spouse about the divorce?
No. After you file the initiating forms with the court, your spouse needs to be legally served a copy of the summons and petition according to the Oregon Rules of Civil Procedure. Our service forms package contains a summons, the forms to show proof that your spouse was legally served, and other forms that may be necessary, such as forms for the Division of Child Support.
My spouse and I are in agreement about the divorce. How can we get divorced fast?
If you and your spouse are in agreement with divorce, after the petition is filed, your spouse can sign and date a form within our service forms package. If your spouse agrees to sign this form, you can finalize the divorce quickly. Once this form is filed with the court, you can use our judgment forms from the default and judgment forms package to file the judgment that will finalize the divorce. Our video tutorials guide you through this process step by step.
Could my spouse prevent or delay the divorce?
No. After your spouse is legally served the summons and divorce papers, he or she has 30 days to file a response with the court. The response will state which paragraphs or provisions your spouse disagrees with in your petition, such as the relief you requested regarding custody, parenting time, or property distribution. Their response may also contain counterclaims, which are requests for relief your spouse wants the court to grant them. Once your spouse files a response with the court, you'll receive notice from the court. If your spouse does not file a response within 30 days, you can file default and judgment forms on the 31st day, which informs the court that the respondent did not file a timely response, that certain other requirements have been met, and request the court to grant the relief sought in your petition. Once the judge reviews the default and judgment forms, he or she will either deny them or, if everything is correct, will approve them by signing the order and dissolving the marriage.
If my spouse files a response, how should I prepare myself for the court process?
Our litigation forms package contains 3 different forms that will prepare you for a hearing or trial that you may have before a judge. Because having documents that justify your request for relief is important, the first form is our petitioner's request for production of documents, which allows you to receive relevant documents from your spouse. This requires your spouse to produce to you relevant documents such as tax returns, pay stubs, retirement fund statements, and, in certain situations, medical health records. These documents can be crucial in proving your case. This package also includes the subpoena for hearing or trial form, which summons a person to attend a hearing or trial to give testimony. This is useful for when a person has beneficial testimony but will not voluntarily attend or needs a subpoena in order to be released from work. The third form in this package is the Statement of Assets and Liabilities form. Generally speaking, a statement of assets and liabilities must be filed with the court and mailed to the other spouse before trial. This form details to the court your position on how each disputed asset and liability should be distributed. For example, your proposed value of all personal property, such as vehicles, furniture, jewelry, and electronics that you and your spouse own, and who will be awarded those items. The items are listed in a spreadsheet that are conveniently tabulated showing each spouse's totals.
When is the divorce finalized?
A divorce is finalized when there is a judgment signed by a judge. This happens after the divorce concludes by either default, agreement, or trial. The judgment form in our default and judgment forms package contains entries for findings and orders a judge would make at trial. All you would need to do is complete the entries in the appropriate spaces we provide in the form. Of course, we give you guidance and instruction on how to do this so you're doing it right. This package can also be used to finalize your divorce if it concludes by default or agreement, meaning there wasn't a trial. We go through each scenario and instruct you on which entry selection you would make in those circumstances.
Can I really complete my divorce on my own?
Definitely. OregonDivorceForms.com was created because most Oregonians already handled their divorce by themselves, but needed a more affordable option with greater instructions and resources. Now, if your situation is very complex, you may need to seek the help of a legal professional to get you through your divorce, but most people can do it themselves. Naturally, all this information may seem overwhelming and complicated, but don't worry. Our forms go step by step through each stage of the divorce. If you are starting your divorce from the beginning, our complete package is recommended. OregonDivorceForms.com was created to help Oregonians successfully and affordably file for divorce using technology and education. Be sure to check out the blogs, articles, and other resources available for free at OregonDivorceForms.com to aid and assist you through your case. You can also connect with us on our Facebook community.